Hello again, my name is Mark Silver. I am a forensic expert in New York. I've done thousands of cases for immigration, criminal, and civil litigation lawyers. I am a psychiatric social worker. I also have a doctorate in psychology. I also am a lawyer and a background in political science and family systems therapy. To my knowledge, I am the only criminal mitigation expert in the United States who specializes in immigration defense work. And that's the program today. This is a CLE that's been heard by thousands of attorneys throughout the United States. I've been lecturing for many, many years, and I've been practicing doing forensics since 2002, 2003. This is a very special kind of lecture and a very special kind of program because, as I said, to my knowledge, nobody else does criminal mitigation for immigration defense lawyers in the United States. I used to go to AILA conferences, and I'd sometimes go up to psychiatrists or psychologists, social workers who have booths and so on as an AILA member. And I would say to them, do you do criminal mitigation? And they'd look at me like, what is criminal mitigation? They would say, oh, well, I do evaluations for spousal abuse cases or U visas. Someone may have suffered human rights violations in their country of origin, so I do evaluations about the harm they suffered because of their claims in the asylum petition. But none have ever heard of criminal mitigation. And just to be clear, that's because criminal mitigation is almost exclusively for criminal defense lawyers. Before a criminal defendant is sentenced, he has the opportunity to present what's called a mitigation report. And there's very important case law on this. And the mitigation report provides a psychosocial evaluation outlining anything and everything that will give the judge insight into the criminal defendant's behavior, judgment, traumas, challenges, anything in the person's past that help better explain how the person came to such a poor decision to have committed this wrongdoing, this crime. Just for clarification, criminal mitigation is also used in pre-plea positions. That is, sometimes even before a plea is entered by the criminal defendant, sophisticated criminal lawyers want the prosecutor to know who the client is. They want to disabuse the prosecutor of biases and prejudices, so you use the mitigation report for that as well. And the really cool thing is, and maybe we'll talk about this if we have time here or another program, in criminal law, if you use a mitigation report for pre-plea purposes, and it doesn't really work out, and the case goes towards sentencing without any real progress, you can use the same criminal mitigation report for pre-sentence purposes. So that's a little introduction. The program today is called Mitigation of Illegal Behavior for Immigration Defense Lawyers. We're going to talk about the major areas. And the subtitle is How Crimes, Fraud, Misrepresentation, and CIMTS Can Be Explained Through the Help of Clinical Forensic Evaluations. I'm going to tell you about my books. This is a book called Handbook of Mitigation in Criminal and Immigration Forensics. It's the 7th edition. It came out just a few years ago. The subtitle is Humanizing the Client Towards a Better Legal Outcome. It's absolutely crucial that this is understood as a core strategy in criminal mitigation. When you go to criminal court, and similar in immigration court, but when you go to criminal court, the prosecutor, the judge, they don't really care about the criminal defendant. They see the criminal defendant as a criminal. And you want to humanize the client to explain their failings and challenges and other issues that led them to undermine their lives, to jeopardize their well-being through their criminal behavior. So we want to humanize the case in criminal mitigation reports and, quite frankly, in other kinds of evaluations as well in forensics that I do for immigration defense lawyers. The other thing about this book is my very first edition of this book, it was one long book. It was actually a shorter book at that time. But I bifurcated the book into two major sections. One is for criminal lawyers, one is for immigration lawyers, because they work in very different worlds in some ways. What I've come to conclude is that this is a false dichotomy, that just as criminal lawyers really need to know the consequences of pleas that their clients give in criminal court, similarly, immigration defense lawyers really need to understand criminal mitigation as a major strategy to explaining the client's behavior and judgment and so on. The other book is Psychosocial Evaluations and Consultation in Civil Litigation, Strategies to Understand and Humanize the Client. I wrote this book really for civil litigation lawyers, but it could be used by any lawyer. The reason I have this book is because in so many of our cases, we need to elicit very difficult and sensitive information from our clients, particularly in sexual orientation asylum cases, U visa cases, domestic violence cases, and so on. And this book helps lawyers understand how to talk to a client, how to get information, what are the major areas that clinical evaluators look at in gathering information, whether it's for a regular clinical examination or for a forensic program. The book also looks at some challenges and issues that I think would be very helpful to all lawyers, including immigration lawyers. Again, the subtitle of the book is Strategies to Understand and Humanize the Client. The strategy is based in a clinical understanding of the client based on a clinical psychosocial evaluation that's undertaken. Excuse me. I really try to integrate theory with practice. I've been lecturing for many, many, many years. I've lectured to, I don't know, tens of thousands of lawyers, certainly. And the best way to integrate theory with practice is I tell lawyers, send me an email and I'll send you back a redacted report that integrates the information from this program, the PowerPoint slides that it's based on, into a real case. Obviously, if it's redacted, the client's name, birthday, and so on, identifying information will be changed or omitted. But it's important, with CLEs of any kind, that it's not just theoretical, that it works in practice. And the best way to show how it works in practice is for the lawyer to see a sample report. If you want to see one, send me an email, put a CRIMMIGRATION sample in the subject line or something very similar. Put all your information in the email so I know you're a real person. I get a lot of spam in my business. I promise you I won't send you back spam or send you Christmas cards or Hanukkah cards. I'm just going to send you back the redacted sample. If you have any questions, feel free to email me. But I really think it's crucial to integrate theory with practice. I have to tell you, I'm also an AILA member, and for many, many, many years, I've been trying to convince AILA National to have this and other forensic clinical programs as part of their national CLE library, and they're just not interested. I will tell you, interestingly, local AILA chapters are very interested, and I've done many programs over the years for local AILA chapters, and hopefully I'll be doing some more next year. So because they don't carry it, and I know you have to go to private providers, and I've done many, many programs for private providers, I want to have all of these programs available for everybody, free on YouTube, that can be seen and reviewed at any time. As I said at the outset, criminal mitigation is not something that immigration lawyers normally think about as part of their ordinary practice, even though it's crucial to immigration defense in many cases. And I really want that as the core idea to be something to be focused on throughout this program. One of the core areas where criminal mitigation is used is obviously waivers. There are all kinds of waivers. And I have a separate program on the criteria, the clinical criteria of waivers that, again, AILA National doesn't have. I think it'll be useful to see. I'm going to hopefully record it this week or next week. So one of the very first things I ask myself when I get a referral from a lawyer is I ask myself, what is the problem? Because when the client calls, the client says, oh, I have to show hardship to my family. I think, oh, it's a hardship evaluation. But when I look a little more closely, there's always one or two other problems. And there may be, for example, fraud or misrepresentation with the client entered the United States, which needs to be addressed. The client may have had felonies, misdemeanors, and so on. So really what a lot of forensic experts don't get, and this is why you get RFEs and denials, there are two issues that are generally not related. One is the evaluation of hardship issues to qualifying family members, and the other is the mitigation that's needed for the illegal behavior. The question is, what is the real problem? And by that I mean, in some cases, you may have a clearly strong hardship analysis, but the illegal behavior is perceived by the adjudicator as so serious that they're not really, frankly, that interested in the quality of hardship issues, because they're so convinced in their own mind that the illegal behavior, in their discretion, warrants a denial. And that's why it's important to think about both the hardships and the illegal behavior. What are you really looking at? What are you really evaluating? What are the strengths and weaknesses of each? How is one important? How is the other important? And sometimes there's a connection between the waiver requirement and the hardship standard. Hopefully we'll get to that today. If not, I promise in a future program. I want to give you an overview of the definition of criminal mitigation. And by the way, some of these issues I use exactly the same when I teach criminal defense lawyers in the United States. So mitigation is a biopsychosocial evaluation of the client's social and psychological history, informed by the facts of the criminal case with appropriate recommendations as a means to minimize the negative legal outcome, either in court or with an adjudicator or prosecutor. Mitigating circumstances reduces the degree of moral culpability or blame, which in fairness, sympathy, or mercy may lead to a more favorable outcome for the defendant. So this is the definition I use when I teach criminal defense lawyers. This is exactly what we need as a definition in immigration defense work when trying to understand our clients' wrongful or illegal behavior. We're looking at a broad psychosocial understanding of the person's history to understand their judgment and how they came to have committed the wrongdoing. So we humanize the case and we get a better sense of who they are and their judgment and behavior, feeling, cognition, and so on. So the big question is, when do you use mitigation? And I'm going to outline that as a core part of the program today. The first is Adam Walsh Act cases. I'm not talking about Adam Walsh Act cases today. I'm not talking about it because I have a completely separate program and I've done many CLEs on it. It's just such a huge and complicated subject that I just think it warrants a separate program, and I promise to do one in the future. Excuse me. The second is bond hearings. The third is 601A provisional waivers. Then cancellation of removal cases, sometimes called deportation cases appropriately. Next, fraud and misrepresentation 601 waivers. Next, VAWA waivers. Next, U-visa asylum cases when a crime occurs. Criminal arrests, convictions, and CIMTs. I've been in this business for a while. I've yet to hear a lawyer give me a precise definition or the consequences of a CIMT. But they obviously are crimes that involve moral turpitude of one kind or another. So let's first talk about bond hearings for the use of criminal mitigation for immigration defense lawyers. In bond hearings, it's similar to a criminal hearing, right, where you have two major considerations, which are risk to community and flight risk. This may have little or nothing to do with the hardship analysis, but hardship can be part of the analysis for the bond hearing. I just want to step aside and repeat what I said before. One of the huge advantages of having the hardship analysis included in the bond hearing analysis is that your client is probably going to need a waiver after the bond hearing. In the waiver, you're going to need the same analysis which occurs as the main focus of the content in the bond hearing forensic report. In other words, you kill two birds with the price of one stone. You can use this report for both the bond hearing and use it almost exactly the same, or maybe tweak it a little bit later for the waiver submission. In bond hearings, I look very closely at family, personal, property ties in the U.S., employment, community ties, client's good moral character, how the client has changed for the better since their past criminal behavior, proof of participation and or completion of rehabilitation programs, even substance abuse, counseling, anger management, and so on. I want to tell you I've done probably more evaluations than anybody in the United States, thousands and thousands, and I've consulted on I don't know how many hundreds and hundreds, if not thousands. I cannot tell you how few lawyers have called me for bond hearings. I would say in the last 20 years, it's probably a dozen. And yet it's completely available for immigration defense work. And in a sense, it's free. It's free because, as I said, the same report that you're going to need for a waiver, you can use for a bond hearing with few, if any, tweaks. So you need it anyway, and it can be submitted. And when I've had referrals for bond hearings, it's been extremely helpful for the immigration defense lawyer because it's broadened their understanding about what criteria and factors outside of just risk to the community and flight risk, giving a much broader sense of the person's ties to their community, family, which make it much more sympathetic and really flesh out the case in a much more complete way. The next area is 601A provisional waivers. Now you may ask, why do you need criminal mitigation in 601A provisional waivers? There's no criminal problem, excuse me, and the person has not committed fraud or misrepresentation in trying to enter the United States. So why do you need criminal mitigation? The truth is it's extremely helpful and it's not usually used except for really a few very savvy lawyers. I'm going to explain why. It helps with weak 601A provisional cases. You know, I see a lot of these cases that are referred where there are no real or major medical or mental health issues. The parents get up in the morning, they go to work. The kids get up in the morning and they go to school. Sundays they go play soccer or whatever. Everybody's healthy, and then 80 or 90 years later, everybody dies. Everybody's okay. But if everybody's okay, there's no major hardships, and there's certainly no extreme hardships. So one thing you can do is look at criminal mitigation. Look at mitigating the person's immigration to the United States. And I'll give you a very common example that I see. A woman has entered the United States as a young adult often, and her husband is petitioning for her to stay in the United States, and she may have a few children. And what I find is that, obviously I take a very careful history of the husband because he's petitioning as a USC for his wife. But then I also take a history of the wife, even though she's not a qualifying family member. And what I often find is that the wife has suffered abuses as a female in her country of origin, with restrictions on her social, education, employment, community opportunities. She suffered misogyny. And in a reasonably high number of cases, she suffered abuse as a female, either in her family of origin or in a prior intimate or romantic relationship, sometimes even in a marriage. And that abuse may have included physical, emotional, sexual, verbal, financial, and other abuses. She's not a qualifying family member, but the reason I put in a paragraph or two or three about this is because it's very sympathetic. It explains her reason for entering the United States, right? It mitigates it. but it does something else. It overlaps with hardship, and this is something I mentioned before. She might have a daughter or two daughters now with her American husband. What is the quality of life going to be for those American daughters if they are forced to relocate with her for all or part of the year to her small town in wherever she comes from, in Mexico, Ecuador, Far East, wherever it is? Won't those American daughters also be subject to limitations and misogyny as females in that country? So here's a great example of how mitigation can be used even in 601A provisional waivers. The next is cancellation of removal. Cancellation removal, because the standard is so high, it is, I hope I remember this off the top of my head, extreme and exceptional unusual hardship. The standard itself, for most lawyers, becomes the sole focus. And yet, we have clients, not rarely, frankly, who have a criminal issue. One of the ones that I get referred to most common, especially in previous year, are individuals who've had DUIs or DWIs. Again, the respondent who has this DWI, and he may have 2 or 3 or 4 over a period of several years, is not the qualifying family member. So why is criminal mitigation important? I'll tell you. In many of these cases, the respondent who had these DWIs becomes sober. And he does it through AA, his local church, family and community supports, and so on. And what does he do when he becomes sober? He's a better father, a better husband. Perhaps he participates in community activities. He takes his kids on Sunday for ice cream or to the museum or for soccer practice. He's leading a safe and healthy life. He's leading a safe and healthy life because of the support system available to him here. Now, what if this man is deported to his, small town in wherever he comes from, where there are high rates of alcoholism, such as Mexico, and he doesn't have AA meetings, he doesn't have his local church, he doesn't have his supports, maybe he doesn't have his family all the time? Doesn't it seem very dangerous and likely that he will return to alcoholism, perhaps to self-medicate? Maybe he'll return to alcoholism because it's cultural, or that's what his family does. There may be a familial history of alcohol abuse. And then what is the quality of life going to be for those children? So you're able to really shape the argument of criminal mitigation here, piggybacking the essential concerns on the extreme hardship analysis for the qualifying children and other family members. Moreover, do you really want those children to grow up in the respondent's home where there was alcoholism? It's absolutely absurd. Would you, if you're doing an adoption case in New York and the kids being transferred to another home, wherever it is, in New York or Minnesota, wherever it is, and the new home has alcoholism, would you ever transfer that kid to the other home where there is alcoholism? Absolutely not. It would be absolutely impossible for all sorts of reasons. Clearly here too, we want to say that we don't want this child relocating for all or part of the year to his father's home, where the father grew up in an atmosphere that was conducive towards drinking. So that's an example of criminal mitigation for cancellation of removal. A huge area is fraud and misrepresentation. The fraud and misrepresentation mitigation is not usually very seriously considered or strong, because very often the client will say things like, oh, I really didn't know. I had an agent or a friend in my country help me fill out the paperwork because my English was terrible, or that person was more educated, or that person said they had experience in filling out this kind of paperwork. That person filled out the paperwork and they committed fraud. I really didn't know. Well, saying that you really didn't know might be true, but it doesn't provide any understanding for the immigration judge or adjudicator to give context as to why this fraud or misrepresentation occurred. If you can give some kind of context or reason, it'll help a lot in having the case granted. I used to go to court, this was many years ago in New Jersey. There was a judge, he long since retired, but he used to say, you know, I need something to hang my hat on. You can't just say things to me in court. Give me something that is reasonable, that I can understand about this client, the issues, the facts, so that I can provide a favorable outcome for the respondent and his family members. And what I have found with fraud and misrepresentation is that if you just dig below the surface, you often find issues. One issue is that clients have often lied. In other words, it wasn't just that they gave their case over to a friend or agent of their country of origin, but that there was more to it than that. And the client doesn't want to flesh out or provide more details because of the wrongdoing. They're trying to cover up for themselves. But in allowing the client to open up about what was really going on in their lives and expressing concerns or major stressors or even traumas that they had experienced in the months or even years prior to the fraud or misrepresentation, you'll get a much better sense of the client's decision-making and judgment, and you may get some really cool information that'll mitigate their wrongdoing. Another huge area is VAWA waivers. In these kinds of cases, the client has a VAWA case which is often quite legitimate, but they've committed fraud or misrepresentation upon entering the country. In these cases, I actually go back all the way to their country of origin where they've often suffered abuse, then look at the immigration and the spousal abuse case itself, because it can be quite powerful, looking at physical, emotional, psychological, cultural, verbal, sexual abuses, and so on. And understanding that their life and the hardship analysis has to be understood and contextualized given these issues that the client has experienced. In other words, it's not just an ordinary hardship analysis about what will happen if this woman has to go back to her country of origin, but I try to contextualize it in her history of hardships. And one of the reasons I do this is because in many of these cases, and this is just one example, because the person has been a victim of spousal abuse, there's a very strong chance that in their country of origin they'll suffer significant social stigma. They may become a pariah. Their ability to integrate or marry again may be very, very low. If they have children that they must return with, it may be that the children will also suffer serious negative consequences, almost as derivatives, in a sense, of the stigma that attaches to the parent. So criminal mitigation is great here as well. Looking at the person's background, which often involves abuse in the person's country of origin, repeated abuse in the context of a VAWA case in the U.S., and negative consequences if the person has to leave the U.S. There are other kinds of issues as well that I've noted earlier. U visa and asylum cases where crimes occur, and I'll give you a case I consulted on not too long ago. This was a woman who had a U visa petition, and it was based on abuse that she suffered with her domestic partner, and she had several children in the home who were minors, and she successfully was granted the U visa petition, and then the daughter was trying to convert her status and adjust based on her mom. The daughter had several issues, including, I believe, petty larceny offenses, and she was denied. So what do? The only thing to really do is criminal mitigation, to try and look at this daughter's behavior of shoplifting and understand the context. This is a young woman who grew up in a home where there was physical, emotional abuse with her mother. She felt a great sense of guilt and trauma, having seen her mother traumatized. There was a lot of uncertainty, fear, anxiety. She had to help care for her younger siblings. And it directed her towards very unhealthy behaviors, including shoplifting. So that's an example where criminal mitigation can help in the context of a derivative daughter of a U visa mom. Another kind of case are asylum cases. There are asylum cases where there are criminal issues. I had one many years ago. This is one of the first times I did a criminal mitigation case for an asylum petitioner, and the guy had committed robberies in stores. He had taken various items, but it was quite a serious matter. It was in Connecticut. The client had escaped persecution from, I think, Syria, maybe it was Lebanon, I can't remember. But he had serious mental illness, including a diagnosis of schizophrenia. And at times he was not able to function very well. And I explained as best as possible to the judge the issues of his psychiatric diagnosis as a way to understand his criminal conduct, the stealing in the stores. And it's very sympathetic, but much more importantly, it's the only thing you can do. The fact that this guy suffered, persecution 10, 20 years ago in his country of origin may have little or nothing to do with his present criminal activities. And therefore, it's very, very important that if there is really no connection, to use criminal mitigation to explain the client's functioning in life and so on in the last X number of months or years, to help give the judge or the TA or whoever insight into this person's conduct and wrongdoing. Obviously, a huge area is criminal arrests itself and convictions in waiver cases. Some of these clients have committed their wrongdoing a few years before. Sometimes a client has committed wrongdoing 15, 20, 25 years before. Sometimes it is a single incident of wrongdoing, criminal activity, and sometimes there are multiple incidents of the same wrongdoing, very typical in DUI cases. But you also have cases where there is different kinds of wrongdoing. I had a very serious case from England where he had I think it was a B&E. He also had an assault, and there was a charge regarding intoxication. It was 3 separate crimes separated by, a significant amount of time, at least several months. 3 different sets of facts, 3 different circumstances, and then you have to tackle each one. The nice thing, so to speak, about having 3 DWIs is that you can collapse the pathology and explain it, hopefully, in the same way. So criminal arrests and convictions are very serious. Sometimes, or more often than not, the criminal defense lawyer did not use criminal mitigation for the criminal case. In other words, it's not unusual when I do criminal mitigation for immigration defense lawyers that I'm starting almost from scratch. And that particularly occurs where the criminal defense lawyer took an immediate plea because perhaps it was a good plea deal. I mean, the criminal defense lawyer may have got a really good offer from the prosecutor's office. And there's no criminal mitigation. In some very serious cases, including white-collar cases and so on, I'll say to the client, didn't your criminal defense lawyer paying the guy $50,000, $100,000 for a white-collar case, didn't he get a criminal mitigation report? And the answer almost always is no. So in these kinds of cases, we're starting from scratch, and it can be very time-consuming, and appropriately, the charges would be different. I want to give an overview then of what the purpose of mitigation is. It's to humanize the client through a sympathetic narrative and induce empathy for the reader. This is particularly true in immigration court, because in immigration court, I was always shocked. You go into court and the TA has the disposition of the crime. The disposition of the crime is useless. It says nothing about the context of the crime. It says when it occurred, and it says the outcome. That's what really disposition means. It's outcome. It doesn't give any context or understanding or mitigation whatsoever. And that's not the fault of the TA. But it then becomes the burden of the immigration defense lawyers to flesh that out. The mitigation report is supposed to document the client's life history, especially if there's a history of trauma, challenges, and so on. And that's particularly true for our cases because we have so many clients that have grown up in the midst of, poverty and misogyny and violence and drugs and alcohol and gangs and social and political unrest and so on. Obviously, we want to look at the client's conduct, the family's physical, psychological, financial ties and hardships. We want to illustrate the client's community, education, employment ties. Very importantly, we want to express the client's contrition, that is his regret and remorse. A very core purpose of mitigation is that professional expression can replace self-expression. When you have a client, I always tell my clients, go to a lawyer, get a consult, even if you don't want to hire the lawyer. The law is so counterintuitive and difficult to navigate. So too, we have a lot of clients that can't explain themselves. They don't have a lot of education. They may have disabilities, language skills. They fear authority. And just like they need a lawyer to explain their legal issues and give counsel, they need a forensic expert to give them the opportunity to be interviewed in a clinical setting to elicit information to express their issues and needs and why they got into trouble in their criminal matter. So it's not just a mental health report. It's a broad psychosocial understanding about the client's history, often with hardship issues. There's something also called the single document theory. I've talked about it a lot when I teach. And that is, this is true for criminal defense lawyers, but for immigration defense lawyers too, they often give a great deal of documentation to support the case. The rule is document, document, document. And it can be helpful sometimes to have a single document, like my report, the forensic report, which is maybe only 20, 30, 40 pages, but that incorporates a lot of the core concerns that could be found in these other document packages. Another very important issue, I mentioned this before, is there's a lot of prejudice and bias in immigration court and in criminal court. Someone comes into criminal court, they have a $2,000 Giorgio Armani suit. It's assumed that they're just really rich. There's prejudice and bias because of gender and skin color and all sorts of things in criminal court. That's no less true in immigration court and for adjudicators. And we want to disabuse the adjudicator of bias and prejudice. We don't want them to guess. We don't want them to fill in blanks on their own. It's our job as professionals to fill in blanks, to explain the person's history and conduct, development, and so on. And that's why these cases really take time and can cost. But it can be very beneficial. I just had a huge case I have finished. It was an immigrant from West Africa, with Sierra Leone. His mother was from Liberia, just over the border. And he had grown up, and he was a forced soldier who engaged in terrible behavior, came to the United States and had a lot of behavioral problems, as one can imagine, suffering horrific trauma with his family, multiple near-death experiences, seeing unspeakable harms to human beings. And he got involved with the wrong crowd, and he was doing some shoplifting. He went to juvenile detention and all sorts of issues. But anyway, it became a criminal mitigation case. And, this guy, when I saw him in county jail, he presented very, very well. He presented as a guy who was thoughtful. He was quite calm. There was no sense of anger. not a person you would associate with the kind of very serious behaviors that he engaged in. And it's easy, I can see, for an adjudicator, TA, immigration judge, whoever, to look at this guy and say, you know, you seem fine to engage in these behaviors. You must really have some kind of pathology. And, you know, a core part of the evaluation concerned looking at this guy's horrific history of trauma experienced in Sierra Leone and looking at it in the broader context of his family's experience as well in West Africa before coming to the US. And it just fleshed out, you know, almost in a psychobiographical manner, this person's very poor decision making, but also his development over the years as he's been incarcerated, his growth as a human being, and so on. Key matters to consider in mitigation are the same key ideas I consider in regular criminal mitigation cases. I think, you know, is this an aberrant decision? Was it misguided behavior? Was it an error in judgment? Was it just foolish conduct? That is, you know, was it just a dumb mistake? Was it done in an unthinking moment? Did the person have diminished capacity, maybe because over the months or years prior to this, they had multiple heavy life stressors? I want to show that the person is not evil, that the person is not bad, but that they're misunderstood because of their behaviors, and that their behaviors can be understood logically and reasonably, clinically, given their psychosocial history. There's sometimes issues of conscious avoidance. Sometimes, you know, there's the client should have known better. And again, we want to show how the client, how his judgment and his decision making was not necessarily impulsive, but based on his psychosocial history of trauma. Many of these clients do not have animus towards victims or towards the community, but they've suffered so much on their own. We want to show redemption. We want to show that there can be balance between justice and deterrence, ultimately allowing the client consideration for his wrongdoing to remain in the United States, most often with his American family members. We want to give the judge a sense, the adjudicator a sense that they're on the winning team. We want to give them a sense that this person who committed wrongdoing is on the right track and has been on the right track for many years, and that there's an incremental process of continual improvement that this person has shown that the judge, the TA, should be aware of, and that we're all on the same winning team, that this person is really going in the right direction, and as a complement has been very crucial and has selflessly cared for his children and wife perhaps, and has tirelessly provided financial care and instrumental supports for his family in general and the home. It's a very important perspective. In my book, but in other programs also, I have something called the 10 R's of mitigation for criminal defense work, and I use the same program, frankly, for immigration defense lawyers. The first R is reality, facing a full narrative. Again, TAs, when they have a disposition, don't have that. Write a paragraph or two about what was involved with the crime. Give some context to it. The next R is mens rea. We learn in law school about intent. Intent's important, but I'm more interested in volition. A broader understanding about the person's frame of mind and judgment. The next R is recency. When did the crime occur? In criminal work, this is tricky, right? Because the crime may have occurred just a few months or a year ago, and it's quite recent. That's not true for immigration defense lawyers who have clients who've committed crimes 10, 15, 20 years before. And the distance, the good behavior from the time that crime occurred till now, in itself is proof of rehabilitation. Repetition to this crime occur again and again. Was it a one-off wrongdoing? How serious is this? Is it, first degree, second degree, third degree? But more importantly, the degrees. What does that actually mean, given the facts of the case? Restorative. Has the client righted the wrong in some way? Rehabilitation. Has the client changed? Will the client change? Maybe the client has fundamentally changed in many ways since this occurred. remorse and regret. Does the client understand and accept his actions? Is there, genuine contrition? Roles. I sometimes contrast the client's role in the criminal matter with the client's role in his life now as father, husband, employee, church member, and so on. And lastly, recommendations. What can be fixed? Who can be helped in the context of the case? The lawyer's role and my role as a forensic expert should complement one another. They should balance one another. Mental health issues and psychosocial history should be mitigating factors that are interweaved and integrated into a coherent whole into the case. I've said it before, I'll say it again. I think only experts should evaluate these cases. Psychotherapists are not helpful because they don't look holistically. Psychotherapists are not helpful because they don't understand and have no experience with criminal mitigation. Therapists don't want their notes handed over. God knows they don't want to testify in immigration court. They may not have the experience. They may be quite concerned about liability and so on. So there are many reasons to have an expert do it, and someone, honestly, that knows criminal mitigation as well as they know immigration defense forensics, because in so many of the immigration defense cases, criminal mitigation of one kind or another is required. Sometimes the clients are in the pokey, right? They can be in ICE detention. They can be anywhere. The last two cases are in county jails. I'm a big fan of Zoom calls, audiovisual calls. Nothing replaces, however, a face-to-face evaluation. Nothing. I don't do Zoom calls for children. That's my general policy. As a general policy, I also don't do Zoom calls for geriatrics when there's a concern that there may be cognitive limitations, dementia, and so on. When I get someone in my office, I really am able to evaluate them in a much more humanistic way. I look at their behaviors, their interaction with me. When I see a face on the screen, if that's all you have, that's all you have. But nothing replaces a face-to-face evaluation. I know it's very expensive to have me fly anywhere. I have two cases in Chicago that are coming up. It's close. It's only, about 2 hours to get there. But it's expensive. You have to pay for flight and hotels, and I understand that. But the lawyer should know, and I always tell the family, I never judge a case by how much the case may or may not cost. I give the client my best advice as to how I will understand their issues, and then it's in the client's court. Just one thing I'll say about this: you can't make any assumptions about finances with a client. I just saw a case where clients sort of, they were struggling financially, and gave them a break because it was just such a sympathetic, amazing lesbian couple. I wanted to help them, and then when I did the evaluation, one of the partners earns almost $200,000 a year, and the second one earns about $40,000. So it was about $250,000 they were making between them. And I thought to myself, there are plenty of immigration lawyers out there that don't make nearly that amount of money. So the bottom line is, I tell the clients how I can best help them, and then they make a decision based on their own finances. And, sometimes you have clients that really are struggling financially, God knows, as first-generation immigrants. They have a sibling or parent or other family member or someone that can help them. A core part of this, which we can't talk about in detail because I have it in other CLE and other programs that I'm going to put up, but in almost every case where there's criminal mitigation, there's psychiatric issues. And I don't just mean psychiatric issues in the context of evaluating the qualifying family members for hardship criteria. I mean with the respondent himself or herself. In almost every case, you see people that have suffered trauma in their country of origin. I look broadly at their mental health issues. I consider clinical and subclinical issues. I always check if there's documentation. For many of these clients, psychiatric care is anathema to their cultural background, and mental health diagnoses are stigmatized. So you really have to ask very, very carefully about these clients' psychological and emotional health and well-being. Some of these clients get assistance from their local church or temple with a pastor or their fellow parishioners and so on. But it's important to ask about these things. It's important to be culturally sensitive. I had a case, this is about 10 years ago, I believe it was Russian, and I saw a father and son. The son was here in medical school. The father had committed very serious criminal visa fraud in Brooklyn. And the father just would not talk about mental health issues at all. And the son, who was in medical school here, I think he was third year, was translating for his father. And he said something I'll never forget. He said, in Russia, there are hundreds of ways to insult a person. There are different kinds of words and phrases and so on. He said, the worst thing you can say about a person is that they're mentally ill. In the United States, everybody and his cousin goes to a therapist, and we're all on medication for depression, anxiety, insomnia, eating problems, and so on. And in a way, it's very, very good. If there are issues, they should be addressed by healthcare professionals. But he stressed to me how so many of these clients that I see, it's not something you talk about. It's so stigmatized, and you need to get under the skin of these clients and really get at the functioning and their health and well-being to understand their psychiatric issues. Just very quickly, what to do if there's a denial. The only joke I know is there's two kinds of lawyers, those who get denials and those who get denials but don't admit that they get denials. It always happens at some point or another. The first thing to ask yourself is, was mitigation available for the clients? Was there mitigation to understand the waiver or the illegal entry or the fraud or misrepresentation, and so on and so forth? When I get a case that's had a denial, or even for that matter an RFE, to me I often look at it as a fresh start, a de novo opportunity to take advantage of seeing the clients in a way that will be fresh and new, and hopefully a second bite at the apple, although that's not clearly the case necessarily when it is adjudicated. I try to also read between the lines. One of the most important things I found when I was referred cases for evaluation that had denials was that, most of the USCIS analysis was about hardship. But that, tucked away at the end was mention of the client's wrongdoing, fraud or misrepresentation or criminal activity or whatever. And it dawned on me that the denial was not really about the quality of the hardship issues as it pertained to the qualifying family members, but rather about the fraud, misrepresentation, or criminal activity itself, which the adjudicator felt did not warrant consideration, and therefore the case would not be granted. Who most benefits from these kinds of criminal mitigation analyses? Clearly, where there's criminal mitigation issues, and sometimes you don't know there's criminal mitigation issues unless you get an evaluation. Clearly, clients with mental health problems, clients who've had their own extreme hardships separate from the hardships of the qualifying family members. Clearly, clients who suffered childhood abuse, trauma. Clearly, cases when there's interfamily dependence. Clearly, when the client has poor language or communication skills, poor self-care, social adaptive interaction, and those clients who have limited or particular challenges with executive skills, cognition, and so on. Those clients who fear authority, a super important issue always to consider in certain kinds of cases, including VAWA and asylum cases, and also if there's a confluence of mental health and social deficits. For criminal mitigation, it's always better to have the expert explain the issues. For criminal court, it's a different ball of wax, but for immigration court, for this reason, I think it's important to have the expert who really understands the criminal mitigation available to testify if necessary, just as you would have the expert available to testify for the hardship analysis. The adjudicator may not know or really care about mitigation issues. And I have to tell you, being in court with an immigration judge can be incredibly helpful. One of my first cases in Jersey, this goes back years ago, was for a judge who we just squeaked by in the morning, and I had the same case with him in the afternoon. I was going to testify again as an expert, which has never happened. And the judge said, you know, you have this case in the afternoon. And I said, yes, I'm aware of that, Judge. And the judge said, you know, you're not going to win the case. It's just not sufficient hardship material. Of course, I ran to the cafeteria and I looked at the case for 2 hours over lunch. But the immigration lawyer ended up winning the case. And I think part of it, and the hardship issues were not strong, but I think part of that was just having the opportunity to speak with the immigration judge face to face and talk about these two incredibly young, wonderful girls. I think their ages 11 and 14 at the time, involved in all sorts of activities in their community. And it's true, the hardship issues were not very strong, but just talking about their progress and how their lives would be undermined and how their development would be jeopardized. And I tried to balance the hardship issues with really explaining the mitigation about why their parents came to the United States from the Philippines and the deficits that they had in their country of origin, their lack of supports in their own development, and how these children would suffer in a very similar manner. Thank you very much. Again, I think this is an absolutely fundamental thing that AILA should have, which is a criminal mitigation for immigration defense lawyers. As I said, I could be off, but I think I'm the only person in the United States that does this. I've done numerous cases over the years for criminal lawyers, primarily federal cases, and I've really transferred those skills to the work I do for immigration defense lawyers. Please don't hesitate to email me if you'd like a redacted sample. I'd be more than happy to send it to you. The books I think are great. Hopefully they'll be helpful. Or if you just want to email with general questions. And finally, I'd be more than happy to present a free CLE for your local AILA chapter anywhere in the United States, either in person or by Zoom. Thank you for listening, and keep watching. Thank you.